about 30 seconds. We're just going to give everyone a chance to get into the room. All right, I just opened the room up, and I'm pretty excited. We've got about 250 doctors on the webinar today. We've had a series of great calls and some information you guys have asked for. This one's pretty important to me, and we'll get some more context on that later on in the call. As a practice broker, this is a pretty important topic that seems to be overlooked quite a bit. I reached out to dental attorney David Varnier, and he was nice enough to put together a presentation for us, and your response and your RSVPs are indicative that it's a pretty important topic to you guys as well. So what we're going to do is, if you see the screen here, David's going to present to us. We are going to have a Q&A session at the end. So if you could all put your questions into the Q&A box, if you have any comments, put them in there as well. At the end of the presentation, David's going to go through and answer all your questions and all your comments and address them. So that being said, really excited again. A lot of people here this morning, and without further ado, I want to go ahead and throw it over to David. He's got a great presentation. David, I'm going to mute my phone, and I'm going to sit back and enjoy this because I definitely want to partake in this information as well. David, take it away.
Great. Thanks, Jonathan. Today, we're going to talk about general estate planning issues that affect everyone, but really the key and the benefit of today's presentation will be dental specific, and talk about the goal of allowing your family to operate your dental practice if you become incompetent or if you pass away. And I'll solicit Jonathan's storytelling about what he has done in the past when families come to him and say, my husband or my wife passed away and we have a dental practice now that we need to address. And he'll explain from the broker's perspective what he's dealing with. But two parts today, start with general estate planning issues and then talk about the goals of dentists that have some specific laws that affect them. A couple of preliminary comments. I'm a California attorney. The presentation today is going to address California laws, and the laws of each state are different. You're not wasting your time if you're here on the call from another state, because the issues probably parallel the laws of your state, but the specifics aren't going to be the same. And so obviously it's important to talk with an attorney, whether you're in California or in another state, about your individual circumstances. We can't write your estate plan just in a broad seminar like this, but the goal is to give you some information that'll help you understand your existing estate plan, and whether you have an estate plan or not, some of the dental specific issues about the goal of transitioning smoothly if something happens to you, and allowing the practice to continue to operate until likely it'll be sold is the goal, and we'll discuss that in the second part of today's presentation. I do want to warn you or apologize in advance. I've got a 4-year-old daughter who has promised me that she will not interrupt Daddy during this presentation, but as many of you know, those promises are not necessarily enforceable in a court of law, and so we'll live with the outcome, but we'll keep it as clean as we can in case we are interrupted. And thank you in advance for understanding if we do get interrupted. So with an estate plan, I'm often asked for investment advice when people hear that I'm an estate planning attorney. An estate plan is not the same thing as a financial plan. A financial plan covers investments and retirement goals, etc. An estate plan covers two issues: what happens if you become incompetent, and what happens if you pass away. And that's it. There are some financial planning overlap issues, so we'll talk about how you deal with retirement accounts. But for the most part, an estate plan really just covers if you become incompetent and if you pass away. There are 4 cornerstone documents in an estate plan. 2 of them deal with what happens if you become incompetent, and 2 of them deal with what happens if you pass away. The 2 that address what happens if you become incompetent are power of attorney for finances and property, and then separately is the advanced healthcare directive that addresses healthcare issues if you cannot communicate on your own behalf. And then transitioning to what if I die, the 2 documents are your will and most likely a living trust that you also would have as part of your estate plan as well, for reasons that we'll explain in a few minutes here. So let's first talk about just what happens if you become incompetent or can't communicate. Well, without any legal documents, there is a mechanism in California under the Probate Code, and I believe all states, where a family member can go to court and say, my wife has had a stroke and is no longer capable of handling her own affairs. I want to be appointed to have the legal right to manage her finances and her property. And the good news is, for those who don't have a power of attorney or a healthcare directive, that is available. But there's going to be cost. There's going to be a delay before the appointment is made by the court for all of the right reasons. If someone petitions to be appointed as what's called a conservator, the court wants to have all family members have a right to contest whether the petitioner is the best candidate. And so it requires a notice period. So it's going to be at least a month, maybe even longer, before the appointment happens. Also, the person who gets appointed may not be your first choice to handle these things. If you've got multiple family members that are all in the discussion to be a candidate, the person who's kind of the most outgoing might be the one that says, I got this, I'll take care of this. But it might not be, and the rest of the family acquiesces to that person who's willing to take the lead, but it may not be your first choice. So those are the downsides of not having something, is there's going to be a delay. The person might not be your choice. And then again, for all of the right reasons, the court rules are that the court is going to supervise the conservator to make sure the conservator is doing everything right, which is great if there's a problem. But in 95% of the cases, the person appointed can be trusted and is doing everything the right way. And we don't want them to have to pay money to an attorney to help them through the court, supervision process and the required hearings that follow on a periodic basis upon appointment. So that's what happens if you don't have any documents in place. If you have a financial power of attorney document, what that document says is, if I become incompetent in the opinion of one doctor or two doctors, and if the doctor or doctors declare that in writing under penalty of perjury, then I appoint so-and-so, Jim Smith, my spouse, as my agent, who will have the following powers. And then the list of powers would be just about everything related to your finances and property: signing contracts, buying property, selling property, etc. Operating a dental practice, to the extent that it's allowed by an unlicensed person. And again, we'll talk about that in the second part of this presentation. And it's immediate if that happens. If the two doctors or one doctor, depending upon what your document says, either one or two, do declare that you are incompetent, those letters from the doctor or doctors get stapled to your document, and it's effective immediately at that point. There's no court supervision of that, and so that's the benefit there. You're choosing your own person. There's no cost of going to court, and there's no delay. You can also do an immediate power of attorney for older people, as in really old, or for people that might be going out of the country. Sometimes it's appropriate to give an immediate power of attorney to someone, and then you revoke it when you no longer need them. So just be aware of that as well. But most people just do a springing power of attorney, which is a power of attorney that only goes into effect if you do become incompetent. There's a separate document related to healthcare. It's called, in California, we call it the Advanced Healthcare Directive. It's actually under the probate code here in California, that document. And that document likewise says, if I cannot communicate on my own behalf my decisions regarding healthcare, I appoint my spouse as agent to make my decisions for me. Likewise, that document's going to give authority under HIPAA to have access to medical records. I'm speaking to a crowd that certainly understands HIPAA and the privacy laws regarding medical information. It also, the Healthcare Directive document also has living will directions regarding end-of-life issues, and there's some options there about what your end-of-life directions might be. And then the document also has an optional section where you can give direction regarding organ donation and the disposition of your remains, what Beatles song they'll play at your life celebration if you want to give that type of a direction in the document. I have to make light of this subject matter a little bit, but those are the additional things that are available in a document for healthcare matters that wouldn't be available if you become incompetent without having put the legal documents in place. You're going to list an agent as a primary agent, but then you're also going to have a couple of backups as well, depending upon the likelihood that the first and second agent won't be able to serve will dictate how many agents you need as backups. I think always one backup is good, and in some circumstances it's appropriate to name 3 or 4 backups. In fact, sometimes you might name an elderly spouse as your first agent, knowing that if push comes to shove, they're probably going to defer to your oldest child or your whatever other backup you have. And so you can even anticipate that your first agent may not actually serve, because all they have to do is do a 1-paragraph resignation, deliver it to the next agent, and that causes the next agent that's listed as your backup in the document to be the effective agent. And the document would say, I appoint Jim Smith as my agent. If Jim Smith cannot serve, then I appoint John Smith as my agent, and you can continue that with additional backups as well. So that's what happens if you're incompetent. And then I talked about the 2 documents being the Power of Attorney for Finances and Property on one hand, and the Advanced Healthcare Directive on the other hand, that allow you to efficiently appoint someone to handle your affairs without incurring court costs, and making sure that you've got the right person that you want in place to handle things. So let's now talk with a little bit more time about, well, what happens if you die? In California, if you die without any documents, no will, no living trust, the property will be distributed according to what the probate code says will happen if you pass away without a will. And I've listed on the screen here the bullet points that discuss those terms, and you'll see that they're a pretty good guess as to what the person would decide. If you're married with no kids, it goes to the spouse. If you're married with 1 kid, the community property goes to the spouse, and the separate property goes 50-50 to the spouse and the kid. Changes a little bit if you have multiple children. If you have only children, it all goes to the children. And then there's even additional terms for people that pass away without a spouse or children as well. And it's pretty much, it goes to the nearest people on your family tree. The bad news is, in addition to having distribution terms that you don't want, is that there will be a delay in terms of distribution. There'll be significantly higher expenses if you pass away without a will or a living trust in place, because the attorney and the executor that's appointed are entitled to large fees for handling their duties associated with the complex probate distribution procedure to get your assets legally transferred from you to the people who are entitled to inherit them. So that's the worst case scenario is you have nothing. If you have only a will, or if you have a living trust but you haven't funded your living trust with your significant assets, such that the assets in your estate add up to over $150,000, probate is still required. And there'll be the delay in an expense associated with that. If you do have a will, the assets will go to wherever you want them to go that you describe in your will, but there will be the delay and the additional expense. What's an estate? What is a part of your estate? Well, it's in essence everything that you still own in your name when you pass away that hasn't been transferred to your living trust, but it doesn't include vehicles. It doesn't include any joint tenancy assets that you own, which would be property that under California law you own as a joint tenant, which by law means the survivor inherits it. It doesn't include jointly owned bank accounts where the survivor or survivors inherit from you automatically. And it doesn't include pay on death assets. Life insurance and retirement accounts are the best examples of those. When you have those assets, you designate with the financial institution where you want those assets to be distributed if you do pass away. Those all do not count against the $150,000 threshold. What does count against the $150,000 threshold usually is checking accounts, savings accounts that don't have death beneficiary terms, and investment accounts, again, that you haven't designated a death beneficiary. And so the solution is, that we'll get to in the next slide, is you transfer those accounts to a living trust, and now your estate has less than $150,000 amount. If you pass away with a will and with a living trust, and your assets in your estate are less than $150,000, probate will be avoided. You're good to go. This is the goal with an estate plan, is to make sure you don't require probate by having more than $150,000 in your estate, and that you do have a will and a living trust. Under this arrangement, your successor trustee will immediately have access to all of the assets that are owned in your living trust. There will be a little delay until a death certificate is prepared for you, but that's a week and a half or so. And then the successor trustee can immediately pay expenses with the money that you have in your living trust, and maybe even make early distributions if it looks like there'll be a lot of money. and ultimately pay all expenses that are owed, and then distribute the remaining amounts or the remaining property as directed by you in your living trust document. Probate court is not required. You avoid the expenses. And then it is important to emphasize one other issue that should be looked at individually for you is we're going to avoid probate if your one checking account with $50,000 in it is in your name. Don't need to go to probate court, but there's a 40-day waiting period in order to access the financial accounts, checking accounts that are owned in your name. Again, they don't need to go through probate court, but you're not allowed to go to the bank and to give them a document called a small estate affidavit that is the legal way of transferring money from the bank to the holding account that you'll set up to pay expenses before ultimately distributing the funds that are to be distributed that you own. So how does a living trust work? Well, I've keyed in a little bit of it there. The purpose of a living trust, if you haven't gathered it, is to avoid probate court. That's the primary reason that living trusts exist. And an additional benefit is, again, to avoid the 40-day waiting period before the agent who's going to handle gathering and distributing can access the funds. And then a living trust is also a way for a married couple to coordinate two estate plans into one document versus having two separate wills. The actual way that a trust works is it's a lot like a corporation. It's not a corporation, but it's a lot like one in that it's an entity separate from you for purposes of ownership of assets and the transfer of those assets. Let's look at, we've heard of trust fund babies, people that have big trust fund accounts for them. Well, in those situations, Joe Zillionaire passes away and wants to leave $10 million to his granddaughter Emily. And he says, I'm going to have my old law school roommate, Jim, be the trustee who's going to hold that money for her and leave some to her, as he thinks is appropriate to leave it to her, and maybe give her an allowance as well. Under that arrangement, the trustee is Jim, the law school roommate, who's going to have control over Emily's inheritance. And then Emily is what we call the beneficiary of that trust. Well, under your living trust, you are both the trustee and the beneficiary. You set up a trust and say all of the assets I transfer to the trust are going to be managed by myself as trustee for the benefit of the beneficiary, who is also myself. If you're married, same situation, except there'll be two trustees, husband and wife, and two beneficiaries, husband and wife. With married couples, if one spouse passes, perhaps obviously the most common arrangement is that the surviving spouse inherits everything. And then usually if there's kids, the kids will inherit everything afterwards. But there's no rule that says that you have to leave everything to your spouse if you pass away first. So with blended families, children from previous marriages, each spouse has the option to say, if I go first, I want to leave such and such to my kids and the rest to my spouse, or whatever you decide to do. The living trust distribution terms can be amended at any time while one or both of the people that set up the trust are alive and competent. If one spouse passes, the default arrangement is that the surviving spouse can also make revisions to the distribution terms. And so and we'll talk about how that might be different for a blended family that might not want that arrangement in a couple of minutes here, and we'll go into that in more detail. But again, the most common arrangement for a married couple is going to be the surviving spouse inherits everything, and then everything goes to the kids afterwards. But that's all the more great example of why you need to talk about your circumstances with your estate planning attorney, because you might want to handle it a different way. A living trust also serves as a power of attorney for any assets owned in the trust. It'll say that the trustee will change upon either death or incompetency. So if you're unmarried and you become incompetent, you'll have a new trustee in place that will have, in essence, the same thing as power of attorney over the assets owned by the trust. If you and it'll say not only if you become incompetent, but if you pass away, the new trustee will be so and so. If you're still alive, the directions to the trustee will be that they are to manage the assets in your trust for your benefit until you pass. And then if you do pass, their directions are to pay the expenses of your estate as far as last bills, etc., last tax return. And then when that's all done, then the assets will be distributed as you direct. Quiz time. I won't actually ask for any responses, but are assets owned in a living trust protected from creditors? Pause for a few seconds here. No, they are not protected from creditors. And the reason is that there's no difference in the ownership of the assets under a living trust. All we're doing with a living trust is trying to avoid probate court and to have distribution terms that allow the most convenience for the successor trustee to do the gathering and distributing. If we could protect our assets from creditors just by setting up a living trust, people would all set one up on their 18th birthday as soon as they were legally entitled to do so, and no one would ever collect any assets from anyone. There are irrevocable trusts that protect assets. That's not what this presentation is about, but I will give the commentary that be careful before you listen to an attorney who says an irrevocable trust can protect your assets. Because what it does involve is basically the same thing as giving all of your assets to someone outside your family, or potentially in some instances to your spouse. But you have to give up ownership, and you have to give up all rights to the assets to do that. And that usually is not beneficial. But again, that's a subject of a different presentation. But if you've heard of an irrevocable trust or thought that a trust could protect your assets, it's a different type of trust than what we're discussing today. The trusts we're discussing today are revocable living trusts that are beneficial in that they avoid probate court and the expenses and delays associated therewith. And then likewise, all of the additional stuff that we'll talk about with regards to dentists in terms of being able to allow your family to operate your dental practice without being licensed if something does happen to you. So summary, how can you make sure probate court is avoided and there's no delays? You make sure you've got a living trust in place. You make sure that your estate has less than $150,000 in assets. That would include transferring your dental practice to the living trust, whether it's a corporation or just if you own your dental practice in your name, transfer the goodwill, the bank accounts, the equipment, etc., which is done via memorandum or changing title to a bank account. You'll talk about that with your estate planning attorney based upon how you own your dental practice. But the short explanation is you transfer your dental practice to your living trust. Again, pay on death assets, joint tenant assets, vehicles, they do not count against the $150,000 threshold if you pass away. We talked about the 40-day delay in being able to access assets that are owned in your name. Even if probate court can be avoided, you still have to wait 40 days before you can access them. Quick comment for actually everybody in every state, because this is a federal law. Back before 2010, so this is a trap, a warning of a trap if you if you're married, this only affects married couples, and you set up your most recent trust documents before, say, 2010. Back then, the estate tax laws were different, and attorneys were rightfully setting up married couples with what we call AB trusts, or bypass trusts is another name for them. That involved transferring assets after one spouse died to a different type of irrevocable trust that would not count against the estate tax threshold. I'll talk about that, the threshold, in a minute. But they would place great burdens on the surviving spouse. Back when the estate tax thresholds were $1 million or $2 million, the AB trust plan was wise to avoid tens or even hundreds of thousands of estate tax that might be owed if you passed away. But the laws have changed. The estate tax threshold was $1 million in 2003. It's now $11.5 million per person. And so unless you've got a lot of money, you're not going to have an estate tax issue, at least at the federal level. California does not have a state estate tax. Other states do. And so, again, great example of talking with your estate planning attorney about whether you have an estate tax issue according to your assets and the laws of your individual state and what planning might be done. This is the one overlap where there might be some financial planning done by your estate planning attorney in order to make sure that estate tax can be avoided, at least to the highest degree possible. Talked about blended families, meaning married couples with kids from prior marriages earlier. That might be an example where you want to keep an AB trust and have it say, if I pass away first, I want to leave my share of the house to my spouse, but I don't want him to be able to change the distribution terms and leave my half of the house to anybody other than my kids from my prior relationship, or anybody else that you want to list. And then likewise, the surviving spouse can't sell it and take the money from that and spend it on her own, on herself, or himself. It's whatever the relationship is there. So again, that's a case by case. If you are married and there are kids from a prior relationship, you might still want to keep an AB trust because it was set up not to avoid estate tax, but to acknowledge the circumstances of your blended family. And again, talk with your own estate planning attorney about that. Children trust funds. If you've got a minor child, you definitely want a child's trust fund for the child. If you don't have one, then the kid can't inherit everything as a minor. And what has to happen is if you and your spouse or just you have passed away, you either want, it wouldn't be the spouse, but if you want, maybe it is, if you want the child to inherit something directly from you, you don't want someone to have to go to court to petition to be the conservator of the estate of that child, meaning their inheritance. Costs money. The person who gets appointed may not be your first choice. There's court supervision, again, for the right reasons, but it may not be necessary. The preference is to have a trust fund set up for the child. We avoid probate court. We make sure you've got the person that you want in place to manage the trust. And it allows you to set up terms that usually will say that you give the trustee full discretion to either keep the money or spend it liberally on the child, or somewhere in between. The trustee will decide, and you can write out instructions to the trustee on, you want to encourage travel, during the summer of college or whatever else you want to do. But the key is we avoid probate court. We don't have to go get a conservatorship order from the court, etc. For children that are over 18, if you leave assets to them and they're 19 years old, you don't need a trust fund for them. But when I was 19, if I would have received a significant inheritance, it may not have been gone within a year or two, like the horror stories I hear, but I certainly wouldn't have been a good saver. I would have probably bought a nice car stereo and some other things that wouldn't have been good investments with that money. So most people, many people do say if they're 19, they can get it all. I'd say the vast majority of my clients will set up a trust fund for someone who might be 22 when they inherit money. That'll last until age 25, 30, maybe even older than 30, with the understanding that whatever money is in that trust fund, the trustee can distribute it liberally. In fact, even determine at age 29 that the child is mature enough that it doesn't make sense to continue operating the trust fund, because there will be some expenses associated with the trust fund, and to just leave the remainder to that child. And again, what you can do is talk with your appointed trustee and say, look, if something happens to me, make sure they're protected, but once it looks like they're capable of inheriting, receiving the remainder of their inheritance, go ahead and give it to them. And again, it's case by case. Your attorney will talk with you about your family circumstances and your kids and have a frank discussion about what you might decide to actually put into place. There are special rules for retirement accounts. We'll talk about those in 2 slides here. First, we're going to talk about guardians of minor children, which is different than a trust fund. For someone under age 18, if you pass away, they need a guardian. They need someone to, in essence, be the adoptive parents. It's not the same as adoption or guardianship, but it's basically the same thing. If you don't have any documents in place, someone's going to go to court and say, I apply to be appointed as guardian of 12-year-old Susie. Again, the risks there are, we know there's going to be expense and delay, but the big risk is the person or persons who apply may not be your first choice to raise little Susie. And so in your will, you say that if I pass away and the mother or the father of my child has already passed away, I nominate so-and-so to be guardian of my minor children. The guardian then has to go to probate court to get a formal order appointing them, which is different than the power of attorney, which is, immediate. If you become incompetent, we just staple 2 doctor's letters to that document, and you don't need to go to probate court for all the right reasons. Again, the court needs to take a look at the will and make sure that it's appropriately done. But then they're going to rubber stamp the nominee that you appoint after the family's given a chance to challenge it. And in fact, usually what's done is with the petition are sign-offs by the family members saying, no problem here, that we approve of this person, and then the court will rubber stamp it. There's 2 guardianship rules. One is guardianship of the person. The other is guardianship of the estate. The guardianship of the estate handles basically the same thing as the trust fund, or the property that's owned by the minor child. And then guardianship of the person is the person who decides what time they go to sleep, are they going to have their green beans with dinner, and all of the parenting roles that are unrelated to finances. And it's usually the same person that's going to be or same married couple that would be the same. But in some instances, you might choose to have someone else be in charge of the money that they've inherited, the minor child, and have someone else raise them with the understanding that the person in charge of the money, the trust fund, is going to, release a monthly stipend to the parents or the guardians to spend money on the child for expenses, and then to release things more periodically. If they get a good enough grade point average, they get a used Honda on their 16th birthday, whatever you decide. And again, with the trust fund, you'll likely give broad discretion to the trustee, but then maybe have a side instruction list that addresses things like the used Honda on the 16th birthday if they're getting good grades, encouraging travel during college, etc. And again, that's for a trust fund for someone that lasts after age 18. We're talking about college, but you get the gist of that. So now let's talk about retirement accounts and life insurance and how they relate to an estate plan. Retirement accounts, the default is you should not name a trust as the beneficiary of your retirement account. And the reason is, unless you set it up a certain way, the retirement account is going to have to be liquidated, or the withdrawals are going to have to be made within 5 years. And tax will be owed on that money, income tax on that money. We prefer to leave it at the discretion of the beneficiary to withdraw money on a more spread out time period, stretch out the retirement account. How it works is you look at the actuarial tables and anticipate the life expectancy of someone who inherits a retirement account, and they'll basically have to take out pro rata distributions each year until their expected age of passing, which is dramatically stretch out the minimum withdrawal amounts, minimum distribution amounts, versus a 5-year period, which applies to a trust. But how do you reconcile that with a child? You have a 5-year-old child, and you want to leave the retirement account for the 5-year-old child. Well, how you can do that is with a children's trust fund that has specific terms in it you basically make a separate standalone trust that is solely a beneficiary trust for that minor child. And then that trust has to have specific terms addressing the minimum withdrawals from the retirement account. Any estate planning will be able to set you up with that. But the message to you is to make sure that you're not sitting on distribution terms right now that leave your retirement account to your existing living trust, unless your estate planning attorney has endorsed that as a plan, because you're going to cause the money to be required to be withdrawn within 5 years. Switching to life insurance. Life insurance, on the other hand, can be left to your living trust. It's just a lump sum of money, and you can leave it to the trust and then have it subject to your trust distribution terms. You can also leave it to individuals, and then within those distribution designations, pay on death designees, usually they have a form that says, if so-and-so, your first person doesn't survive you, who is your backup? My problem with those forms is that they typically don't allow for any complex distribution scheme. If so-and-so doesn't survive me, I want 1/3 to go to this person and 2/3 to go to that person. But just know that you can send in written instructions to the financial institution and pretty much put anything you want in place, even though the forms don't allow it. it's a good idea to involve an attorney if you get any pushback from the financial institution, but just be aware that you can't have backups, and you should have backups rather than just naming one person like your spouse as the beneficiary. You should have backups listed with the designations, whether it's life insurance or a retirement account. Understand that life insurance death benefits account against your estate for estate tax purposes. So if you have $2 million in assets when you die, but $10 million in life insurance proceeds to be paid out, you're going to have an estate tax issue because you're going to have over the $11.5 million threshold by $500,000. There are strategies, financial planning strategies to avoid estate tax if you own life insurance or you're going to buy life insurance. It involves a different type of irrevocable trust. But the main thing is to talk with your estate planning attorney to make sure that you don't have any estate tax issues. Hopefully you do, because it means you got a lot of money, not a lot of life insurance. I don't. You may not either, but it's a good lesson to be aware of as far as estate tax issues with life insurance that is significantly high. So we've now talked about all the estate plan issues that affect you, whether you're a dentist or not. Let's now transition to the bread and butter of this presentation for dentists, which talks about the dentist's goal of making sure that the dentist, or better put, the dentist's family, can continue to operate a practice if you become incompetent or pass away, and immediately have the ability to sell the practice as well, if that's what's desired to be done. They can keep it for a little bit. We'll talk about it. It's a 12-month period. But what do we have to do, and what happens if you don't have anything in place, or what you have in place doesn't, under California law, set things up the way they need to be set up? So first, we'll talk about incompetency. If you have a power of attorney that says the right things and you become incompetent, the good news is that if your practice is owned in your name versus your living trust, the agent can run your dental practice while you're incompetent. The bad news is that this is not the ideal situation, because it means that when you ultimately pass away, probate court's going to be required, and your family's not going to be able to operate the practice until the executor is appointed by the probate court. And there's going to have to be just the general probate court issue that we talked about at the beginning of this presentation. Family's going to have to go through probate court, which nobody wants to do. So I hesitate to even put any sugar or frosting on that issue and say, yeah, it's a good news. If you own the practice in your name, your agent can operate the dental practice if you become incompetent, because in that circumstances, you're not set up for what needs to happen if you pass away. And if you become incompetent, it's too late to set up the living trust, most likely, at least without a court order allowing someone to do something like that for someone who's incompetent. So we don't like that situation. We'll talk in a minute about the ideal situation, which involves a certain type of living trust that's separate than the normal living trust. But before we get to that, let's talk about what happens if you pass away and you don't have a living trust, or you have a living trust that's not funded, or you have the typical living trust that owns not only your dental practice, but also your house. In those circumstances, depending upon the actual circumstance, if you have nothing in place, the agent will be allowed to operate the dental practice once appointed, but not until that. And that's going to be multiple weeks, multiple months, more likely, before the practice can be operated. And so you're going to lose a month plus of time between your passing away and when someone else can come in and operate the dental practice. Not good. And I'll ask Jonathan in a few minutes here about his experience with families that have dealt with a dentist that has passed away in their family.
Yeah, David, I apologize. I kind of muted, almost like you were going to ask me, because, this is the part, and, I apologize. It's kind of selfishly having you on today, because unfortunately, as a practice broker, this is the thing that I deal with that's very, very frustrating, because, I have a grieving spouse or family that calls me up. And, when I hear about the situation, I just cross my fingers on that phone call and I say, please, please, please have some sort of estate planning or trust in place, because as you mentioned, and I'll let you get back to this, I hate to interject, but it's so passionate to me that in the absence of this, we often can lose the entire value of the practice. And if that practice is worth $1 million, and for a lot of dentists, that's part of their retirement or nest egg or the money that they want to have for their family, it's gone, and it's gone in a very, very short period of time because, and I was watching your slides, and that probate experience we talked about, that if we have to go to probate, unfortunately, in my realm, that's when we start to have the conversation that all value is essentially going to be lost. So I apologize for interrupting you, but that's the part where it really, really strikes a chord with me that I hope that somebody's working with someone like you to put estate planning in place and put a trust in place. So I apologize. Take it away again, David. It's great information. I appreciate it.
Yeah, well, that's you're emphasizing what I take for granted is the understood risk. I'm going to have a specific question for you regarding the timeline in a second here after I give a couple of examples. On this slide, we talk about two different things. The first bullet point is the potential trap that dentists are in right now. I'm going to guess that there are a lot of dentists out there that have a living trust and have funded it with their dental practice assets, but they also, for reasons that that you can understand, have transferred other property to their living trust, like their house, financial accounts, etc. That's what I have. I've got everything I own in my one living trust. That's what everybody should do, except with dentists, where there are some unique laws in California that give an unlicensed dentist the ability to continue to operate a practice in certain circumstances. Here's this way it works. If you have a living trust and you pass away or you become incompetent, but the living trust owns assets other than the dental practice, then the good news is that the successor trustee can immediately sell the practice assets. That's a great thing. We're happy to hear that because we don't have the delays that you just bemoaned as far as the delays for probate court before anybody has the legal power to transfer the dental practice assets. But in California, the successor trustee can't operate a dental practice without a license in that situation. So let's look at the second bullet point. What's the solution? Well, under California law, the legislatures have designed a situation where if you have a separate living trust that owns only the dental practice assets and has a bunch of terms in the living trust that affect and limit what the trustee can do with the dental practice and what ownership rights the beneficiaries have, the unlicensed beneficiary of the trust have, then the successor trustee can, despite not being a licensed dentist, operate the dental practice by hiring licensed dentists, licensed hygienists, etc., and keep the revenue. The revenue goes to the living trust. And in California, the law under the Corporations Code and the Business and Professions Code allows this to occur for 12 months. The idea being that may be how long it takes to, do the transition, list the practice for sale, etc. And you can understand the legislation, why it's there. They're worried about the patients. And the balancing is we don't want unlicensed dentists owning dental practices, but in this situation, we don't want a bunch of patients thrown out on the street. If there is a licensed dentist and hygienist, usually the ones that are already at the practice can continue to do the work for the family that now owns the dental practice. So the solution is you have a second living trust that will only own the practice assets or the stock in the corporation that owns the practice assets. And then that has to have, that second living trust has to have some specific terms in it regarding what the trustee's responsibilities are, the limitations on the trustee, the limitations on the beneficiaries, etc. And if you've got that document in place, we accomplish the goal of allowing the family to continue to operate the practice seamlessly and to sell the practice without waiting for probate court. So that's the big goal here. That's the reason everybody didn't waste their time waiting till the end of this presentation, either to confirm that they already have this in place and to feel good about things, or to contact their attorney and to say, hey, I'm wondering what happens to the practice if I pass away. And some estate planning attorneys might say, oh yeah, the successor trustee can sell it. And the follow-up question is, well, can they operate it? Because they're not licensed dentists. And to point them to this information, to where you understand under California law, at least, that the family can operate the practice if a certain setup is made with an additional living trust. And I'm going to guess that other states have something similar to this because, again, it protects the patients more than anybody else. That's the motivation, among other things. With the family, we want to protect the patients, right? And this allows that versus doors closing and patients missing appointments because the family can't operate the practice without being licensed to do so. So as promised, Jonathan, if someone has a living trust that owns the practice but doesn't meet the requirements of being a separate trust that only owns the dental practice, and they can sell it, what is the diminution in value, with each week or so that goes by when the practice has been closed? And sent announcements to the patients, hey, Dr. Smith has passed away. We're looking to do a transition here, but all appointments for the next 3 weeks are postponed. How does that affect the value of the practice?
Yeah, it's a great question, and it's profound. When we're selling a dental practice, essentially what we're selling is goodwill, and goodwill is the propensity for the patients to return to that practice to have their dental care rendered. And if the doctor passes away, that letter going out before we can get in and talk to the spouse and start to get some interest in the practice is also problematic because the letter has to have a continuity plan in it. In other words, we found another doctor, someone's going to treat you. Sometimes I do find out that the letter went out and it just announces that the doctor's passed away, and there's no plan. So the patient's interpretation of that is I should go out and find a new dentist. Well, if that's been done, then that's going to be attrition to the patient population and your value is going to drop substantially. I can tell you guys that I am aware of a practice, I can't tell you where it's at, that the doctor went out ill and the doctor passed away, I want to say a year ago. And I don't know if the patient population knows about it yet, but it was a solid year that the family did not tell the patient population that the doctor had passed away, because the patients kept asking, is he okay? When's he coming back? Now, that's not what you should do, and that's not an ideal situation, but it's highly indicative that they were well aware of the asset that they had was dependent upon the number of active patients. And if those active patients felt that doctor was not going to come back, the attrition would start quite rapidly. So, David, I feel like I'm taking the microphone from you too much, but, I want to throw it in there, and we'll probably come back to it, that most dentists have probably the most awkward thing you do in life, but a letter or a directive in case something happens to me, here's what you should do. And I don't know if you can list it in David's documentation, but, call Jonathan or not me selfishly as a broker, but call someone, usually a practice broker, because they can execute the sale of your practice quickly because they're working with buyers. But call this person, and that helps because obviously you have a grieving spouse, a grieving family, and when these things happen, it's very, very traumatic. It's very, very traumatic, and I don't say that for shock and awe value. It is just very, very, very difficult, and especially if that family is dependent upon that money from that practice to keep going. As you can imagine to me right now, the 250 plus people on this call, everyone that is listening to this, if David's nice enough to allow me to put this out there on iTunes or a podcast so other people can listen to it, you can imagine, you can feel it right now, like what I'm saying is hitting home, that it wouldn't be a good situation. So David, geez, I apologize. I took so much time on that, but it's a pretty passionate issue. That's what I'm so glad you came on today. And it's indicative of the large number of people that are on this webinar listening to us, but please take it back, but please ask me questions if you need to, because I'm enjoying this. I'm going to mute myself.
Yeah. Well, and you just spawned a couple of quick thoughts from my end. For my law practice, I've got a 2-page list of everything from my life insurance, retirement account information, and where the folders are in my home for accessing stuff. It's got passwords, and that's a good point for estate planning. Is you want to have a list of all of your online passwords. Those are invaluable to the family if something happens to you quickly. And I just keep mine in the flap of my estate planning binder, thinking that any thief that comes into my house is going to look at the estate planning binder and be scared of it like it's a rattlesnake or something, because it's going to be something boring. And they're not going to look in there for my passwords. Maybe I'm naive there, but the point is to have that. But in there it says, talk to the following attorneys and office mates about what needs to be done if I pass away. And while I confess I don't have a updated case. This wouldn't apply to dentists, so I shouldn't even mention. I don't have an up to the minute case list, that gets updated all the time. But I've given at least enough direction so that my family knows what needs to be done as far as finding out where to address things if something happens to me quickly. Also, let's talk about the family that does, for justifiable reasons and without a moral wrong. If a family says, "Hey, look, the associate dentist can handle all of the patients. The hygienists are, willing to work. We're not going to tell anybody, and we're just going to keep appointments and maybe fib a little to the patients about the fact that so-and-so, the dentist, has passed away." I don't fault families for choosing to do that. I don't know that it's a moral wrong under that circumstances. The patients are probably best treated that way, but it is a breach of the law. It's a crime to practice dentistry without a license or to own a practice without a license. I'm not certain it's a crime, but it sure sounds like one to me. I should hesitate for saying that, but it certainly is something where there's going to be penalties involved. So yeah, I guess it is a crime. We don't want to get into that situation. We can solve it by, again, setting up things that allow the family legally to seamlessly operate the practice, etc. That is the presentation. I absolutely encourage people to, talk with their own attorney about all of this stuff. It's been a refresher course. We've talked about some dental specific stuff. I'm available. I'll put my slide up with my contact information in a second, but I do encourage people to talk with their own existing estate planning attorney. That attorney is likely competent to address these issues and stay under the roof you're already under as far as the attorney. But I certainly am available to chat with people. If you've got questions, I'm going to put my email up, but I'm going to also be looking at the Q&A log here in a second, and we'll get to as many as we can to talk about today. But the wrap up here on this slide is a reminder. I'm a California attorney. What I've discussed applies to California dentists and residents, but the laws are probably the same in your state. But whatever state you're in, your circumstances may be common, but they also could be unique. Don't rely on this presentation. It's important that you talk with an estate planning attorney about your circumstances. My contact info here, I'm going to leave this slide up while I look at the question and answer log here.
And David, while you do that, and just in case, I would like to make this available on a podcast because there are a lot of people that tune in. So while you're looking at those questions, so there was a lot of questions that came in. I'm kind of surprised, but not surprised in the fact that there's a lot of passionate feelings about this, and it's a good topic. So if you want to just look at those over real quick, what I want to do is I want to read your contact information out loud for those that are driving in their car or listening to this while they're jogging or at some later date on the podcast version. So Attorney David Barnier is located here in California. His phone number is 619-682-4842, and it's www.barnierlaw.com. That's BARNIERLAW.com. And you can also reach him at that same domain. That's David, DAVID, at barnierlaw.com, BARNIERLAW.com. David, I apologize. Perfect. Hopefully I read that off so people can understand it and enunciate it.
You don't have to apologize for reading my information, and understand I'm not billing anybody who calls me or emails me with questions. That's how it works. Some of you may end up having reasons that you decide are worth hiring me to help out with an estate plan issue or any dental issue. But the majority of you are going to check in with me. My experience tells me, and I'll answer a question. We'll chat for a little bit, and you'll never get a bill from me because that'll take care of things, whether because you're going to your existing estate planning attorney after clarifying something with me, or don't need anything, or just decide to not address things. So don't think you're going to get a bill by checking in with me. May not be able to respond right away. Today's a busy day, but next week, starting next week, I am available and will respond as soon as I can. If you've got a really complex issue, I got to look at stuff, obviously, that might involve billing, but you won't offend me by asking, and I'll just tell you if I need to look at that. But that's obviously a benefit to me of being invited by Jonathan to do this. It gets my name out there as a candidate to do things. But again, I will very unselfishly say, if you've got an estate planning attorney, do not abandon that attorney. Use the information you learned today to check in with your attorney about any questions you have. And again, I'm available if something comes up. All right, I'm looking at Yeah, go ahead.
Yeah, sorry, I appreciate that, and I guess I forgot to preface the introduction. One of the reasons, as John heard today, is that we have worked together quite a bit in a professional capacity. David does a large number of dental transitions, working with both buyers and sellers. So that's how I've come to know David and know him in a professional capacity. And I can say I've heard nothing but great reviews from dentists about him and his communication skills and his willingness to work with them. So David, there's a lot of quick Q&A there, and those people are kind of waiting for that. So I apologize about this interruption, everybody. I'm going to let David go ahead and handle that Q&A, and I'm going to go back on mute. David, if you need me, call on me and I'll come off mute and I'll help you out. Or I'll answer a question. I won't help you out, but I'll answer a question.
Yeah, I'll call you out, Jonathan, and feel free to butt in on something, because there might be something here. I don't know what's in front of us, and you'll jump in if you feel it. First one's a Dave question, not a Jonathan question. My understanding is that you can have more than one revocable living trust. Yes, you can have 20 revocable living trusts, much like you can have 20 corporations or 20 LLCs. Most people don't need more than one. An example of someone who does need one is a dentist, for the reasons we described today at the end of the presentation. In order to allow the family to seamlessly continue to operate the practice, the dental practice has to be owned by a trust that owns nothing but the trust. So if you've got a house, you've got to have your typical estate plan that owns the house, and then a separate living trust that owns just the dental practice. Another example where you'll have two living trusts is if you're single, set up a living trust, and then get married, you'll probably set up a second living trust jointly with your new spouse, but you won't abandon your first one. Again, you'll talk with your estate planning attorney about what the best plan is based upon your circumstances there. And I'm going to kind of rifle through these as quickly as I can, thinking that's the best approach, Jonathan. So if I get rushed, slow me down. What are the federal tax consequences? What are the federal tax considerations versus states? Federal tax, state tax right now, if you pass away with 11.5 something million dollars in your estate, every dollar above that is taxed at a rate of about 50%. California has no estate tax. Other states do have estate tax, and it's usually a threshold lower than 11.5 million. You can answer that question with a Google for your particular estate, and also your local estate planning attorney will be able to answer that question and talk with you about what planning steps might be available to reduce as much as possible what state estate tax might be owed if you're subject to state estate tax without having the $11.5 million plus the state that would make it subject to federal estate tax. Jonathan, here's one for you. Jonathan, which states are you available to work in?
So that's a good question. In the state of California, you have to have a real estate license to transition a business opportunity. So it varies state by state. Most states do not have the parameter that you need to hold a resident real estate license to transition a business opportunity. So the answer to that question is that I'm a licensed licensed real estate broker in the state of California. I do a lot of transitions in California, but I can do transition assistance all over the country unless your state requires it as a realtor. I would suggest if you want to work with me, part of that directive that David had talked about is that you list, we have an introduction, your spouse or your family knows who I am. So in the case something happens, they can contact me. And if I'm not licensed there, then I'm not going to do it in the broker capacity, and I will counsel your family member at no cost. If I am a licensed broker, then I can take the listing and I can transition the practice for you. And when I say counseling, I'm not going to transition it because I can't, but I would give them directive of who to talk to in that state, and then how to go about finding the right person to transition the practice, and then doing it quickly. Time is of the essence, unfortunately, if you pass away suddenly. So I hope that answers the question. It depends on the state that you're in. And
only because it's clearly selfless on my part, I'll tell people out of state, legally, I can't bill you for helping you out with something there. There are attorneys that believe that they can practice law in other states. I don't cross that line, but I'm happy to field your phone calls and email questions with the understanding that I'm going to defer to your local attorney to advise you on your state's laws, but there might be a question or a practical issue where I can identify something. So feel free to check in with me if you're out of state. I'm happy to do it, but you are going to have to talk with an attorney licensed to advise you regarding the laws of that state. I had a will and trust in 2003, but changed it in 2005 after I married, and revised it after we had our first child in 2007. I've had a prenup signed, and we have separate property. Should my husband have a separate document? The answer is actually in California, the way I set up estate plans for married couples, might not need to talk with your attorney about whether or not to do it. But a living trust for a married couple can own both community property, which is what we have as the marital law in California, as well as separate property of each spouse. The issue is commingling, whether you have a trust or not. If you own separate property, don't commingle it with community property. Otherwise, under California law, it's all deemed community property that you now own 50-50 with your spouse. But that's a question that does need attention directly from someone who's going to look at your actual circumstances, what the prenup says, and what assets you own, and everything else. But there's really, the answer I gave is accurate, but really it just emphasizes that you need to talk with an attorney about your individual circumstances as far as what should be the setup. But you should know that a living trust for a married couple owns not only their community property, but can also own their individual separate property without by itself making the separate property 50-50 owned by both married partners. I have a family trust already. Any suggestion on how you name the unique second trust for the corporation? You can name a living trust anything you want, just like you can name a corporation anything you want. I think, is it David Letterman, whose production company is Universal Pants, Inc. Jack in the Box is owned by Food Maker, Inc. You can name your living trust anything you want. I don't encourage you to get cute because it might cause some delays if you are going to a bank or something like that. But typically for a second, what I suggest to my dentists who set up the second living trust is they name it the John Smith Dental Practice Living Trust, something like that. But you really have no limitations on what you can name it. You do have to abide by rules in naming your professional corporation, but not your living trust. I am 100% owner of my dental practice corporation. Is it a convenient idea or beneficial to give part of it to my wife or not? I'd want to know why you wanted to do that, but if you're thinking it's going to do something as far as asset protection or estate planning, the answer is no. And if the wife is not licensed, she can't be an owner of the practice or an owner of the corporation's shares. She'll have a community property interest in them, but she can't be the actual owner by name in those. And so, again, talk to an attorney specifically, but the quick answer is almost certainly you would not want to transfer ownership of shares in a corporation, a professional corporation, to an unlicensed spouse. Here's a question about irrevocable trusts. Do they protect assets? No, or yes, they can, but not something we've discussed today. It's a separate issue than the living trust we've discussed today. I quizzed you. I said, do living trusts protect assets from creditors? No, none of the trust information we discussed today will cause your assets to be protected from creditors. There are conceivably some irrevocable trusts that will protect assets from creditors, but not without transferring ownership and control to someone other than you. And so rarely are they worth the trouble, but talk with an attorney who might consider himself or herself qualified to address those issues, but be warned that make sure you're getting everything they're promising in writing in case it doesn't work out, and be very wary of attorney or non-attorneys that try to set these up. I know there are some non-attorneys that try to set up irrevocable trusts under asset protection, and it's practicing law without a license. Do you recommend a separate trust for each house or property? No, I don't, unless there's a reason to do so. But you can own 100 houses in one living trust. It just means that if something happens to you, you'll address the distribution terms in that document. A related issue is you might want a separate LLC to own every property if it's an investment property that's earning rent. For us, that's for, interestingly enough, asset protection. If you have 100 rental properties and something goes wrong on one and you're not covered by insurance and you get sued for $1 zillion, all of your assets are going to be, that are owned by the person or entity that owns that one rental property, are going to be exposed. Whereas if you have a separate LLC for each property and something goes wrong, only the assets within the LLC that's operating the subject property that's being sued will be exposed. So if you have a separate LLC for each rental property, something goes wrong on one rental property, you don't have insurance to cover a lawsuit, the only assets that will be exposed as to that lawsuit will be the bank account holding the rent and the for that property and the actual property itself, assuming you've set everything up the correct way. But that's the idea. If you set everything up the right way for an LLC, that's the purpose of setting an LLC up in the first place. Or a corporation is to, there's some tax benefits sometimes, but really it's asset protection to limit liability for any business venture to the assets related to that business venture and not all of your other savings and other business venture assets as well. Oops. Just hit escape on the computer screen. Sorry about that. Yep, there I am. Hi there.
That's okay. We lost a slide. It's the beauty of Zoom and being from your home. So I appreciate it. But you're back up there.
Yeah.
Great information, though. I mean, we have a lot of questions. How many more questions do we have? That's a lot of people. I want to make sure we cover them all.
Yeah, we got a couple more here. Is the living trust that just has your dental office set up, and is it set up the same way as the other living trust that has your personal properties? It is for the most part. Let me start slideshow here and get back to the back. Yes, it is, but I mentioned that. Sorry for causing you a seizure there. The difference is, the one difference that you mentioned is that it can only own the dental practice assets. And then second, it has to put restrictions on what the trustee can do with the dental practice assets, meaning the trustee can't actually operate the practice without a license, but the trustee can hire licensed professionals and other restrictions on what the trustee can do. And then likewise, what the beneficiaries can do as owners of the assets that own the dental practice. So there are separate terms in the living trust that'll only own your dental practice versus the typical living trust. When a non-dentist comes into my office and I set him up with a living trust, that living trust looks the same as my living trust that I have for myself, but the dental practice living trust terms, 90% of it is the same, but 10% of it is different. Again, because we have regulations about what the trustee can do. One more question here. Can you have more than one person in the unique trust run your practice in case the first one can't serve? We talked about this a little bit, but there's a related issue that's worth attention. Yes, your living trust should have backups that are designated if your first listed person can't serve for any reason. One backup at least, maybe multiple backups. So that's the simple part. The question that comes up more often is, should I have two people acting at the same time? Forget the dental practice part of it. I've had married couples come to me and say, we'd like our son and our daughter to both be the people in charge of gathering and distributing, just because we want to give them equal dignity. We want them both to feel like we're treating them the same. They're going to get a 50-50 split of what we own, and we want them to be 50-50 responsible for all of the steps. It's noble, it sounds good, but in practice, to have two people appointed, whether it's as an agent under a power of attorney or as a successor trustee or anything, not good, because they may not agree on what to do for all the right reasons. They might defer to each other. No, we've got to decide, who to sell the dental practice to. I'll let you decide. No, I want you to decide. That type of an arrangement, which can be frustrating for everybody involved, including them, most importantly. versus having one person that you say, you're going to be the one in charge. And you can tell them, I want you to talk with your brother about this, but ultimately you're the decision maker here. And that's how it works with healthcare decisions under a healthcare directive. Anybody you appoint to make decisions, especially if it's a child, is probably going to consult with the rest of the family before making any decisions, right? I would like to think so. But that doesn't mean you should name 4 people that have to unanimously agree on something. Ultimately, you just want one person to make the decisions and ask them to get input from the family members, of course. Unless I'm missing any questions, Jonathan, that's all I see. Get anybody who didn't get a chance to submit a question, there's my contact information. And but am I missing anything, Jonathan? Anything more?
I think you got it. I do want to acknowledge that there was a large number of people here today, and if you didn't submit your question, or if you didn't want to submit it publicly, David, I think it's safe for me to say that they can definitely reach out to you if they have a private question or a private matter that they did not want to put through the Q&A in front of all these people.
Yes.
Safe to say, yeah. And for those who might be listening on the podcast, again, I just want to read this off to you, www.barnierlaw, BARNIERLAW.com. So, wow, we didn't really lose anyone. Everyone kind of stuck to this entire call, which shows me that it's a really, really good topic.
They might be asleep. I've been known to put people to sleep when I talk about estate planning, but seriously, that's great to hear. It's not the most exciting subject matter, but it's obviously important.
No, definitely. And I think it's one of the biggest mistakes if you miss a conversation or you miss a presentation like this and you don't pay close attention, when you realize that you need to listen, it's going to be too late. So I appreciate it, David. We had a lot of people in here on behalf of all the people on this webinar. They are saying thank you in the chat right now. And I want to say thank you to you on their behalf. Great information. And again, if you guys want to reach out, David's also a transitions attorney, transitioning for buyers and sellers when practices are bought or sold, obviously, but working with dentists for dental transitions. So David, with that being said, I appreciate it again. Any parting words you want to say to them? I'll give you the mic for 10 seconds. I'll take it back and then I'll go ahead and terminate the meeting.
Yeah, this was fun. I appreciate the opportunity to have been invited and to be able to participate. So thanks for including me.
No, I appreciate it. Yeah, Zoom is interesting. Zoom is fun. And, we had a good time and we'll stop it there. So thanks everyone from the call. I asked you again, take advantage of this time. It's an unprecedented time in history and in your dental career. And, we're giving as much information out as we can possibly. And I want to ask that you guys all stay healthy and stay safe and enjoy this time with your families. And if you have any questions, email me and I can relay them to David, or you have David's contact information, you can get hold of him directly. So with that being said, I'm going to go ahead and terminate the call here. And again, I appreciate everyone being on. Thank you.